everything that is in their business that has an economic benefit to them that nobody else knows is important and important to protect. So a trade secret itself is the classic definition anyway, is anything that's secret that isn't publicly known that you can derive economic value from, and more importantly, what your competitors might derive economic value from knowing.
Hello, and welcome to A Higher Law, a cannabis podcast from the Dykema law firm. I'll be your host today, Brett Gelbord, a partner at Dykema and a member of the firm's cannabis group. For more episodes, you can find us at dykemapodcast.com, youtube.com/dykemalaw, or by searching A Higher Law wherever you get your podcasts. On today's episode, we'll be discussing trade secrets in cannabis, including the unique challenges the industry faces and best practices for operators to protect their own trade secrets and confidential commercial information. Joining me today is my colleague Steve Zeller of Dykema's Intellectual Property Group. Steve, thanks for being with us today. Why don't you take a moment and let our audience know what it is you specialize in?
Great. Thanks, Brett. Thanks for having me on. So as you said, I'm in the intellectual property department. I am a patent lawyer and uh, other intellectual property that I specialize in. Um, I'm unique in the sense I do both litigation, both patent litigation, trademarks, copyrights, and I do prosecution of patents and trademarks, and also a lot of counseling on intellectual property, in particular on how companies can um, protect different types of intellectual property. And I've been doing this for over 20 years.
Okay. Um, it's a fascinating area of the law, and I think one that is people are curious about, and that there might be some misconceptions about. So, why don't we start sort of at the ground floor here? And when we're talking about trade secrets, I think a lot of people might jump in their mind straight away to things like, the secret formula for Coca-Cola or something like that, and they might think, well, I'm just a business that's growing cannabis, plants in a grow operation. We don't have a secret formula, so maybe this isn't something we need to worry about. So I guess why don't you start with some sort of basics and how that thinking in terms of the secret formula for Coke is maybe a little narrow.
I think you're right. I think that's a common misconception that especially smaller businesses have, that they don't think that they have their own secrets that are valuable to them. And it's definitely been my job to try to help counsel people to realize that, you know, everything that is in their business that is has an economic benefit to them that nobody else knows is important and important to protect. So, a trade secret itself is the classic definition anyway, is what anything that's secret that isn't publicly known that you can derive economic value from, and more importantly, what your competitors might derive economic value from knowing, and that you have taken reasonable steps to protect that information.
Okay, so I guess I'm thinking of um, maybe a cannabis processing operation where you have people, processing, dried flower into pre-rolls to be shipped off and packaged and sold. And maybe they've figured out after years of trial and error a way to set up their workflow so that table A, where employee is doing one task, is 6 inches closer to table B than it was 2 years ago, and that shaves off, in the aggregate, many hours of time from moving back and forth between the tables. Um, on a larger scale in terms of layouts and workflow processes, is that something that might fall into that category?
Yes, those are perfect examples because something that may seem really basic has, what you've developed over a long time of, as you said, trial and error, and that's where it gets its value because you've invested into figuring out how to streamline your process and extract those efficiencies out of your business. Um, and the competitor just starting up would love that information because they'd like to be the most efficient right away. And you want to make sure that you're once you've done that, it's protected and it's not going to go out the door to somebody else because then you'll lose your advantage.
That
So
makes sense. And, just thinking about this in light of the recent sort of rule that was issued by the FTC banning non-competes in most settings, as someone who practices a lot in the employment space, one way that a lot of our clients try to protect this type of information is through non-compete obligations for, a lot of their workforce. Um, we usually try to couple those with confidentiality agreements and things like that. And so I guess the question is, you know, is a confidentiality agreement, um, you think, sufficient to try to protect that kind of information, or are there other things that an employer needs to do to make sure that specific information is protected?
boy, that's a great timely topic and really should drive home how important it is to start making sure that you're doing all the things you need to do to properly protect your trade secrets, because you can't just or you if these rules go into effect and survive, then you won't be able to just say, well, no, you can't compete in this industry for a couple of years. You have to make sure that your former employees are locked down with not being able to disclose your trade secrets. So the non-disclosure agreements and confidentiality agreements are and should be sufficient, along with everything else you need to do. It's good to have standard operating procedures in place. So you make sure that everybody gets signed up when they get hired. You also give training and uh, you know express the importance of the confidential information of the business and use that as part of the culture of their your company and your business, um, to help and so make sure that employees understand that it is important. um, but then you also need to make sure you're doing the things to keep that information secret and only in the hands of employees who need to know. um, Everything electronically needs to be protected, and passwords. If you have hard copy documents, they should be stamped, confidential, trade company trade secrets, or like stamps like that. Um, and it's the same when you start getting to vendors and third party contractors who come in. You also have to make sure that they're locked down through such agreements and that you're not just sharing your stuff and these uh, uh, confidential information with just anybody. So,
I think that second bit is something that I know I've seen, in litigating some trade secret issues, which I've also done. Um, you know, you, you go through the checklist, right? Okay, did you have this person sign a confidentiality agreement? Yes. Okay. Are they aware that this information is supposed to be confidential? Yes. Okay. This does it, derive independent economic value from the fact that you only know it? Yes. Yes, it does. Okay. All right. So what? What do you do to make sure that this information stays secret? Oh, well, it's just on our network where anyone can access it. It's like, okay, well, that's but that's a step that you need to make sure you're taking if you really want to make sure that you know when push comes to shove, if it's in front of a judge, um, you've done everything that you're supposed to do so that you could get an order from the court, you know protecting your information.
and I just want to add on that. I think that that's not a step that's usually within people's mindset when they are, starting a business, and it's a startup, and there's, two or three employees who are all involved, and then as they grow and grow, you have to change the way that you are protecting your stuff because you can't run the business as it grows as if it's still a three-person startup. Like you said, it's just something that you should be cognizant of in the beginning of how you have to protect your stuff going forward.
Yeah, and that's a good point. The startup aspect of these things, and this is something that I've said before on this podcast. A lot of our clients in this space, you know, are sort of laser focused and have been since day one on their regulatory and licensing compliance, with their state cannabis regulator, because that's the core of their business, right? They need to make sure that they're doing everything they can do to protect their license and make sure that they can continue operating legally within their state framework. And sometimes other considerations, sort of basic employment law things, you know, making sure you're taking the steps that you need to take to protect your trade secrets. Those things kind of fall to the wayside. Just not because I don't think it's because they don't think it's important, but it's just you only have so much bandwidth, and you need to make sure that you're compliant. And so that's, I think, a great reason why it's important for businesses in the space to have access to counsel who can flag these issues for them, and help them address them. Um, I guess moving, having sort of discussed what a trade secret is, and um, that businesses within the cannabis industry, probably have them, even if they don't even realize that they do. Um, what typically is the route for trying to protect your trade secret if you think an employee has maybe run off you know, with your floor plan, like we were discussing earlier, or
Hmm.
you know,
Right.
what's the first step?
The first step would be you want to have an investigation of your own side of things. Um, Frequently there might be evidence that somebody was emailing some confidential information outside, or even just taking their laptop and assessing whether that they have actually, put a thumb drive into it and checked. So the forensic aspects of looking at what former employees have done is really important. I know some companies will, employee will leave, they'll turn in their laptop, and that laptop might be, um, repurposed a day later and wiped out. And you can't do that. You have to at least be cognizant of the fact that you might have to do a little bit of investigating first, and especially when you find out that somebody is going to a competitor or staying in the business somewhere else, and just to double check. Um, that once you find like it has happened, that there has been some breach, that some confidential information was taken or being used, um, a lot of times it's just important to let's just send a letter, and we'll send a letter to the employee reminding the employee of all their obligations. Hopefully, you had some kind of an exit interview that where you stressed um, eh, the importance of your trade secrets, and it's good too sometimes in an exit interview to have an acknowledgement that the employee recognizes that their confidential information shouldn't be disclosed and that they're still bound by agreements. And if that's the case, you just point all that out to the employee. But that being said too, it might be important to put the new employer on notice, and whoever that employee is with, and just you don't have to accuse them of anything, but it if you don't know, especially if you don't know, you can just say, look, this employee was under a lot of obligations. We hope that you respect that. You don't ask that employee to disclose anything of ours, and at least put both the employee and the new employer on notice that you're watching. A lot of times that can make things you know I guess end any issues. Um, but at least they know that you're watching.
Hmm. That makes sense. Yeah. Um, we do the same thing in, if there's a, suspected breach of a non-competition agreement, which we'll see if we get to continue doing that work. But, same sort of thing. You send a letter to the new employer saying, hey, just want to let you know, this person has these obligations, and you see what happens. And in that case, in those circumstances, often, if things escalate, the next step is, you file not just a complaint and a lawsuit, but usually you move for either sort of emergency temporary restraining order or some kind of preliminary injunction in order to have the court enter an order, prohibiting the other side from either using your information or working at this competitor. Um, and I presume it's a similar next step. for the trade secrets.
Yes, yes, it is. It's once you get into court, it's not as simple as a non-compete because you know right away that somebody is um, working for a competitor and violating the non-compete. When you have trade secrets, it's um, you might not suspect that they were stolen, but if you do a forensic analysis and you do know that it was stolen, and if, or there's a competing product coming out, then yes. Going into court and asking for a TRO may be the most proper thing to do uh, if it's something is imminent, something that harm is going to be imminent. Uh, it's not always easy to get a TRO, um, but somebody's opening a new store near you uh, that you know is being using your trade secrets. That could be a situation where a TRO might be appropriate.
Now, most plaintiffs or employers in this situation have the option, depending on the parties involved and what's going on, they might have the option of choosing between state and federal court. Um, Historically, businesses in the cannabis space have not had the same sort of full access to federal court because of the ongoing federal illegality of cannabis. It's a question as to whether rescheduling to Schedule 3 might open that up a little bit more, depending on what point in the cannabis supply chain your business is. You may have maybe a better chance of bringing a a trade secret claim in federal court. There might be some issues if your business is directly plant touching, um, but if you're one step removed from that, you might have a better shot at it. Do you see a advantage between trying to do a case like this in federal court versus state court?
In some ways, it's going to be depend on the court that you're in or the jurisdictions you're in. I mean, the federal courts obviously will be different, but you can, I think, get a cleaner case in federal court. A lot of times, a lot quicker, than having it drag on in the state court. The nice thing about it, though, is almost all states have adopted the Uniform Trade Secrets Act, at least for the most part. And in the federal level, it's the Defend Trade Secrets Act, which is based on the Uniform Act. So the law is really similar through most of the country, whether in state and federal. So it really becomes more of a procedural look at how you want to do it, unless you are across state lines. If you're across state lines, I think it's a lot easier to do it in federal court. But if you're entirely within a state, I think it becomes whether that particular court might give you a fast resolution. Um, I definitely would look for places that would give me an injunction quickly.
Mm-hmm,
Um,
mm-hmm,
so it could be a procedural aspect. Like I said, we haven't talked about business to business disputes,
mm-hmm,
um,
mm-hmm.
and that might be more uh, appropriate in the federal court system
That
typically.
makes sense. Yeah, in cannabis, we don't have too much interstate um, dealings, at least not when it comes to the final product. That's
Right.
completely disallowed. But um, there are multi-state operators who have a presence in several states, and you also have businesses who will sort of have basically become just sort of brand licensing businesses that will enter into partnerships with local producers, um, and then they'll share their trade secrets, their formula for their recipe for whatever gummy they make or whatever kind of extraction techniques they have, um, and they'll license those out to different entities in different states, and then they're operating from whatever base of operations they're in. That appears to happen, and not run afoul of the Controlled Substances Act, because I suppose it's just it's really an intellectual property transaction at that level. Um, so yeah, those operators, they might have a better shot if there's a business to business dispute at getting into federal court. Um, that makes sense. Um, I guess just to take a step back at the when you were describing your practice, you mentioned patent law and patent prosecution, and I guess I just want to highlight that something doesn't need to be patentable in order to be a trade secret, right? And probably I may be wrong, but I think probably the majority of things that are considered trade secrets are probably not things that you would hold a patent in.
That's exactly right. And the patent stuff, at least in this area, or is going to be more on the technical side or on the plant variety side. Processes, like we talked about, extraction processes, or the recipes for making gummy bears. It's all those innovative product type areas that would be patentable. Um, but the trade secrets extends to any, like we said, anything that is secret that you can derive economic value from, like your customer lists, your marketing strategies, as you said, your layout, a way of saving uh, 30% on your production is probably not a patentable idea if it's, as you said, like layouts or um, how the process flows. That's not necessarily patentable, but it's certainly a trade secret because it is something that gives you economic value, and your competitor would um, also derive economic value if they knew it. And so there is lots of things that run of the mill business practices can be considered a trade secret that will not qualify as for patent protection.
Okay, that makes sense. And but that the fact that it doesn't qualify for patent protection doesn't make it any less of a valuable trade secret. I
And
think that's the thing that we I want to drive home for people.
right, and that's actually true. Um,
Have you come across any sort of new trends, just more broadly speaking, in trade secret protection? Anything that you've seen that is either been really effective, or maybe things that have flopped in front of a court that companies should take note of.
yeah, so one of the things in every trade secret case I've ever been involved with, um, there's always the question, and the defense will always ask, that or accuse a plaintiff of not defining what the trade secret is.
Mhm.
That's so common; it's always there, and plaintiffs will a lot of times try to be uh, cagey, I suppose would be the word, of exactly what they are. And I think it makes a lot more effective litigation strategy if you have defined your trade secrets up front and you know exactly what it is. And that all really boils down to um, at the beginning, writing them down, you know, uh, putting them in a database somewhere of this is what our company considers trade secrets. Uh, I think, nobody, a lot of people might advise against that, but when it comes to the litigation aspect, if you've done that and you can show that that specific thing was taken by this employee and given to another party, it goes a long way, and it becomes a lot easier to prove too, and it gets you a lot closer to getting an injunction early and preliminarily if you can make that kind of showing. So I like to, now I've tried to counsel people, and I didn't do this. I actually would always say never write your stuff down. But I think that now it is much better and a much better practice to keep track of it, um, and to write it down and to have your just as a company might say, well, here's all my patents in a list, and say, here's all my trade secrets that, and what you're doing to keep them secret. Have it all documented. Have it. This is only on this area of my system, of my
Yeah.
network. Only these employees have access to this. Um, just that kind of documentation will be great when you try to enforce it. You
Yeah.
know, relatedly, I'm just saying that's actually great when you are talking to investors too,
Mhm.
whether investors or you're going to do a sale on later and sell your company. When you can put that in front of them, so they know exactly what it is. They know what your process have been to protect it. That goes a long way too.
That's a really good point. I mean, I'm not really a deal lawyer, so it's not something I've really ever thought about. But we're always just thinking about trying to protect the economic value for the business as a running business. But yeah, as a business owner, if you're looking to um, make sure that you are conveying the actual value of your company and the assets of your company to either for financing or for a sale, yeah, having something like that handy, that makes a lot of sense, Steve. That's a really great point. Um,
So I would say I've done a lot of due diligence on deals, and when it comes to the IP, and look at that, and more, I have seen both investors and buyers want to know what the trade secrets are.
mhm.
Again, I used to counsel don't put it down, um, but I think more and more want it, and so it's always good to have that.
Yeah, I mean, I could understand the hesitation on the business owner standpoint, especially in
Hmm.
a lawsuit, right? Because you're making public filings, and I guess the concern is, well, if I say what my trade secret is, then my trade secret's not going to be a secret anymore, right? It's going to be out there in this complaint. But I guess that's where, again, you want to talk to counsel maybe, or someone who's experienced with trade secret matters, so that you can figure out a way to provide a description of the trade secret that's generic enough that you're not giving away anything, but that's specific enough that when you put in front of someone, they understand what you mean.
Well, like I'll just put out the example we've
Mm-hmm.
said of the layout and
Mm-hmm.
efficiencies in processing. You you can describe that in a way that isn't uh, a revealing of what it is, but
Mm-hmm.
what the effect of it is, and the steps you're taking to protect it.
Yeah, that's good advice. Is there anything that we haven't covered that you think is important for our listeners to take away from this conversation?
Well, I didn't. We kept talking about employees, and I do think it's important just to raise out there that um, your collaborators, your vendors, everything that comes in and touches your business that is going to have any exposure of what you're doing, they also need to be locked down. There needs to be good agreements, good non-disclosure and confidentiality agreements with them, and prohibitions against use of anything that you've disclosed. So those are very important too. It's not just the employees we're worried about.
That's a good point. Yeah, and that just highlights the sort of far-reaching, um, far-reaching aspects of this topic, and I think is a good reason to remind everyone out there to speak to your counsel about these issues. And this is a pretty specialized area of the law, so if your lawyer doesn't know about it, ask him to or her to find someone who does. Um, so I guess that's it for us today. Thank you very much, Steve. It's been a real pleasure. I think this is going to be some useful information
Yeah.
for our listeners out there. And thank you again for being here. And
Okay.
here's a reminder that you can find us by searching A Higher Law wherever you get your podcasts. Once again, I'm Brett Gelbord, and we look forward